Well, there's no question that Wyeth versus Levine has had a profound impact on the legal seminar industry. I remember being on a preemption panel in late February of this year. I think it was the Thursday or Friday before Wyeth was decided. And the main topic, given that Wyeth was expected to be, and Regal were supposed to be a 1-2 punch, was what, if anything, was going to be left of state tort law in the wake of Wyeth versus Levine. And as the plaintiff's lawyer, it was my job to find the silver lining and to espouse what appeared to be an unfounded optimism over the process. And then Wyeth versus Levine was issued, and the past 3 to 4 years of most tort litigation, pharmaceutical tort litigation in this country, was radically changed. What happened and why, and what are the lessons of Wyeth versus Levine? First of all, although I don't think you have the Wyeth versus Levine Supreme Court decision itself in your materials, and I'll apologize for that if it's not there, you should read it because it really is one-stop shopping on not only preemption in the specific context of prescription drug approval by the FDA, but all of the essential case law that the Supreme Court has issued on various theories of preemption in various contexts are referenced and explained in Wyeth versus Levine. It is also, I think, it reflects some of the best writing of the justices both on the majority and dissent side in terms of explication of the decision, the historical background of the FDA and prescription drug litigation, and the record in the case. And certainly from the standpoint of litigators, and I would guess trial judges, that makes the decision much more useful. Before the Supreme Court issued Wyeth versus Levine, preemption was the hot issue in every piece of prescription drug litigation, including single incident cases like the Levine case itself and vast multi-district litigations like the Vioxx litigation, Bextra Celebrex, the various SSRI litigations. And preemption was raised as a pretrial matter, as a matter of law, on motion to dismiss or perhaps on summary judgment. And the two toughest obstacles and most expensive and time-consuming obstacles that plaintiffs were facing in prescription drug litigation was, number one, preemption, which could wipe you out at any phase of the pretrial or trial proceedings, and number two, Daubert. And the same underlying theme was present with respect to both motions, which is that these are highly technical and scientific medical matters. They're not for amateurs. They're not even for plaintiffs' experts. They're for the real experts, the FDA and the drug companies' experts. And there was a tremendous split of opinion throughout the courts on these preemption issues. Some of it was fact-specific, some of it was policy-specific, some of it had to do with which policy and philosophy a particular court was buying into. And cases were on appeal in various circuits. And I think that not only from the standpoint of a plaintiff's advocate, which I am, was it fortuitous that this particular case was the case before the Supreme Court when it decided prescription drug preemption. I think that the entire system of litigation benefited because the record in Wyeth versus Levine was of a complete trial. It was not something that went up on a motion to dismiss or summary judgment where there was lots of room to argue about what the facts might have been, what each side would prefer the facts to have been. The trial court had found facts on a complete record and the case had gone through the Vermont appellate system, culminating in the Vermont Supreme Court's decision. And while that might not have been enough, I think for once, and I won't say for once, but in this case, the Supreme Court majority decision is at pains to say that it is not revisiting the trial court record, the jury decision. Those are matters of fact. They are decided facts on the record, and among those facts were that adequate warnings would have made a difference in this case. The lack of warning caused the loss of Diana Levine's arm, and so here's a case where the warning made a difference and the warning was in the record. Not all preemption decisions are that clear. So you have a trial court record and you have deference to a trial court record. The other thing we have is a majority decision per Justice Stevens that goes through the entire history of the Food and Drug Act, the Food, Drug, and Cosmetics Act, and the reasons why historically there was no preemption of common law tort claims. The 1930s Act would have included a compensation program, but it was argued that wasn't necessary because state tort law already supplied compensation. So that record is clear. There's also a clear historical record in the case of inadequate resources on the part of the FDA going back as early as the 1950s and culminating in some particularly critical congressional reports on FDA inadequacy in 2008, 2009. And so the problem of agency capture, is the regulated industry able to capture the regulator, was something that was of real concern to the court. Now that's a political and economic reality, and I think it's a good thing that the court dealt with it. Not every justice in the majority thought that that was particularly important. The concurring decision of Justice Thomas, I would submit, is a key opinion to read because it is a pure anti-preemption, pro-federalism, supremacy clause argument. Justice Thomas, at his absolute clearest in delineating his judicial and political philosophy and his view of the Constitution to reach the perhaps counterintuitive ruling for those who think that Supreme Court justices are always result-oriented, that there could have been no preemption in this case because tort law is a matter for the states. So I think if you read the Wyeth versus Levine decision, you get a very clear account from different perspectives of the phenomenon of the FDA, a federal agency with undoubted expertise, nonetheless being held hostage in a war over tort reform and being subject to political pressure. And in fact, what happened in this case was what your mothers always warned you against doing, which is don't be too cute and don't be too clever. The FDA, via Congress, had never purported to preempt state tort law. Well, as of 2006, there was an agency a pronouncement and a little preamble called the 2006 Preamble, where all of a sudden, in a one-sentence, one-liner, the agency said that tort law would interfere with its mission. Well, this was a surprise. It was also the catalyst for all of this preemption litigation that has gone through the federal and state courts. When the majority looked at that preamble to decide whether or not it was entitled to deference, which is the key to preemption, the court in no uncertain terms decided it was not due to any deference. The 2006 preamble, quote, does not merit deference, not just because it wasn't Congress itself speaking, but because, as the court says, in 2006, the agency finalized the rule and without offering states or other interested parties notice or opportunity for comment, articulated a sweeping position on the Food, Drug, and Cosmetics Act's preemptive effect in the regulatory preamble. Quote, the agency's views on state law are inherently suspect in light of this procedural failure. The agency didn't do due process. If you want some of the interesting insider background on some of this, I did supply the amicus brief that my office filed on behalf of the National Conference of State Legislatures on this preamble point. And the point of that brief was to make a factual point for the record that basically in 2000, when the preamble was underway, everyone was assured there would be no preemptive effect in it. In the waning days of 2005, right before the preamble was to go into effect, literally on the afternoon of December 30th, those who were supposed to be consulted began to get phone calls that, oh, by the way, there would be preemption in the preamble after all, but they were not able to get a copy of the document. I think this type of process, literally of sneaking something through, did not impress the Supreme Court in a positive way and led and made easier a finding that in this specific instance, what the agency had tried to do was political, it was not a matter of expertise, and it was not done correctly, either from the standpoint of express procedures for approval or basic fundamental fairness. So I think that's another lesson for litigators, for judges, and for agencies. The stakes are very high with respect to this industry, with respect to the agency, with respect to who controls the FDA, how much it does, and how well it does that. And there is always this pressure to game the system. I am particularly impressed with Wyeth versus Levine because in this instance, a majority of the Supreme Court was able to look at a factual and procedural record and to perceive that when the system is gamed, health and safety is compromised, and was able to strike a blow against preemption, which I think will be, at least for now, the definitive word.